Hi, all. I wanted to talk to you about what I'm calling the problem of horrific precedents. When US v. Morrison was decided in 2000, it was a shock to most legal scholars, for like US v. Lopez, it was nearly unprecedented. And I mean that in the legal sense. That when you read the first paragraph of the decision you have in US v. Morrison, you'll see that it cites to the recent Lopez decision 5 years before, and then jumps back over 100 years to the so called civil rights cases and US v. Harris, both from 1883. I made quick reference to the civil rights cases last week, which was the decision that overturned the desegregation laws passed during Reconstruction and eventually allowed segregated Jim Crow facilities to be sponsored by state and local governments. But what's US v. Harris? That case involved a KKK style group breaking into a prison and dragging black prisoners out, beating them all, and killing one. The ringleaders were charged under federal law for the illegal beatings and murder. But the Supreme Court ruled that Congress lacked constitutional authority to pass the Reconstruction laws under which they were indicted. Essentially, that the government could not reach non economic violence. The Supreme Court ruled that the federal government had no authority to stop private individuals from murdering black people across the South. The decision would de facto give legal sanction to the systematic lynchings that would suppress most attempts by black citizens in the South to defy Jim Crow laws over the next 70 years. Harris itself cited as precedent a decision, US v. Cruikshank from 1875, which had faced a situation where a band of white defendants had been charged with surrounding a county courthouse during a disputed election and killing 100 blacks and a couple of white allies defending their right to vote. The court threw out the charges against those white defendants as, again, beyond the reach of the federal government, thereby unleashing the wave of white murder and terrorism that led to the violent overthrow of multiple southern state governments and the replacement of Reconstruction governments by white racist Redeemer governments. So, in citing to Harris the civil rights cases and Cruikshank, in part of the decision not in your excerpt, the majority opinion in Morrison carefully avoids citing to these horrific facts from those early decisions, just blandly citing to the legal substance of those earlier rulings, which most scholars had assumed had been overturned or made moot by decisions made after Brown v. Board of Education. One twist on this story is that the Supreme Court had actually, before the Civil War, been quite supportive of strong federal laws restricting the right of private individuals, at least when those individuals were accused of being runaway slaves under the Federal Fugitive Slave Act. So the story of federalism is darker and more complicated than even the modern precedents you're reviewing indicate. For more on that darker earlier history, you can check out a piece I co-wrote a number of years ago, linked in this piece, A New Birth of Freedom, The Forgotten History of the 13th, 14th, and 15th Amendments. But this does raise the issue of what it means to cite to the substance of past precedents while ignoring the often horrific facts underlying those cases. As with talking about framers' intent, the usable history of our nation in explaining the meaning of the Constitution is much more complicated than a lot of legal analysis often wants to admit. In any case, that's all for this week. Talk to you soon.